Thanks so much for coming back to What the Heck is Happening in HR. One of our favorite contributors, the attorney known as David Miklas. David comes from the law offices of David Miklas, PA, with 25 years representing employers in labor and employment law. He works with small businesses or the HR director to really get you an answer. He is a sought after author and speaker, and he has spoken as a guest lecturer at more than 30 universities throughout the U.S. His office is in Fort Pierce, but he has clients everywhere in Florida. He works so well with small businesses and the HR directors, and it's because he owned businesses. I also like the fact that he answers his phone. David, thanks so much for coming back to What the Heck is Happening in HR. For our podcast disclaimer, please visit the episode description. Thanks so much for coming back to What the Heck is Happening in HR. And today we are so happy to have the attorney who knows it all, at least when it comes to employment law here in Florida, and that's David Miklas. Thanks for coming back, David.
Sure. Thanks for having me.
So, I want to ask you about the Pregnant Workers Fairness Act and what is it, and if you can, and if you have time to talk about how it interacts with PUMP and ADA and how it all
Sure.
goes together.
Sure.
Thank you.
Okay. So PUMP deals with the Department of Labor, and it involves when a woman comes back after giving birth and wants to pump breast milk for her child. That is very different from the Pregnant Worker Fairness Act. That really has been around in 95% of its current form for several years. Very minor things have been changed recently, but it's in the news, and a lot of people never comply with the law to begin with, so it's good that it's in the news. Now, the difference between the Pregnant Worker Fairness Act and the ADA is, well, first of all, pregnancy is not a disability, but this new law brings in a lot of the pregnant-related matters into line with what most HR people have been dealing with the ADA, with disability type accommodation. So the Pregnant Worker Fairness Act was passed and signed into law at the end of 2022. And it basically requires employers with 15 or more employees to make reasonable accommodations for employees and applicants whom are affected by pregnancy, childbirth, and related medical conditions. So specifically, this is something that makes it unlawful to fail to make a reasonable accommodation to the known limitations of such employees unless the accommodation would impose an undue hardship on the entity's business operation. Now, that term undue hardship is something we see typically in ADA claims. The standard is very similar. Also, this new law, the Pregnant Worker Fairness Act, requires or makes it unlawful to require an employee, a qualified employee affected by such a condition, to accept an accommodation other than a reasonable accommodation that's arrived at through an interactive process. So you can't just force, the business can't just force its choice on the woman unless they interact and have that interactive process. Also, you cannot deny employment opportunities based on the need of the business to make reasonable accommodations. Also, you can't, and I say you, I'm talking about the employer, can't require these kind of employees to take paid leave or unpaid leave if there's any other reasonable accommodation that could be provided. So you can't just say, well, it's easier for us if we just put you on leave so we don't have the headache of any of this accommodations. And then finally, you can't take any kind of adverse employment action with regards to either the terms or privileges of employment against an employee who asks for an accommodation under this new law. Now, the EEOC is the agency of the federal government that is tasked with both interpreting the law and enforcing it. And they've already given us some examples of reasonable accommodations that many women in these kind of situations would ask for, such as reduced lifting requirements, added restroom breaks, and providing for stools. Now, this already is a law. It went into effect in the summer of 2023, and the EEOC has given us a little bit of guidance. They issued a document, quote, what you should know about the Pregnant Worker Fairness Act. And in there, it talks about some of the things I just talked about, that you cannot require an employee to accept an accommodation without at least having a discussion with them about the interactive process. Also, you cannot require an employee to take leave if there's any other reasonable accommodation that can be provided that would let the employee keep working. Some other examples that the EEOC has given us is the ability, if a woman wants to sit down more regularly or drink water or have a closer parking spot or have flexible hours. Maybe if she's has morning sickness, she wants to come in an hour later, things like that. Additional break time to use the restroom or eat or rest. Being excused from strenuous activities if she asks for it, not if the employer wants to do that, paternalistically. Now, one of the things in the EEOC has issued proposed rules. They haven't completely gone into effect yet at the time of this recording, but what they've told us is that unlike the ADA, this new law allows an employee to be, quote, qualified even if they can't do the job. Even if they cannot do the essential functions of the job, they're still covered by this law. And the reason is because the inability to perform their essential functions is temporary. You can only be pregnant for so long. And so basically, as long as the worker can perform the essential functions in the, quote, near future, then they're covered. So what's the near future? The EEOC's proposed regulation says generally within 40 weeks. That's a long time. But that is what they're saying they're going to interpret this as. So if an employee needs some kind of leave to recover, such as from childbirth or from a miscarriage, that would trigger this law. Similarly, this would cover limitations that are episodic in nature and related to either pregnancy or childbirth, such as a lot of pregnant women have high blood pressure that's related to pregnancy. Also, some, and I didn't realize carpal tunnel syndrome could be related to pregnancy or childbirth, and also anxiety. So these are the three examples the EEOC has given us. Some other ones that are buried are if a woman needs time off to get an amniocentesis, if she wants leave for IVF treatments, if there's fatigue that's related to pregnancy, if she has back pain related to pregnancy. Now, that's not an exhaustive list, but those are some very typical things. And there are some other ones that a lot of people don't think about. So this applies also to current pregnancy, past pregnancy, or potential pregnancy, or lactation.
Wow.
It also applies to the use of birth control. So whether or not the employer, supports birth control, doesn't support it, if the woman needs time off to go get birth control, that would trigger this. Similarly, if she wants infertility treatments, if she decides to have an abortion, all of these things are covered by this law.
Wow.
So yeah. Now, in general, under the ADA, we know that typically we're guided by doctor's notes. If we're not clear about something, we ask the doctor for clarity. Same thing would apply here, except in 4 situations. The EEOC has told us an employer can not ask for a doctor's note if these 4 things come up. Basically, you have to take the woman's word for it. If she says, I'm pregnant and I want to carry a water bottle with me or drink water. If she says, I need an extra restroom break. If she says, I need to sit down, or if she needs breaks to eat or drink. So you can't basically say, well, you need to prove you're pregnant and need this stuff. This is very typical kinds of things. So these are the only 4 situations that the EEOC is telling us you don't even get to ask for a doctor's note for that kind of stuff.
Wow.
Now, as a result of this law, most employment places have a new poster hanging on the walls now. And there's 3 different places in the poster that specifically talks about pregnancy accommodation. And then finally, the EEOC, every 5 years, they update their strategic enforcement plan. It's basically the areas that they're going to focus on to litigate charges of discrimination. And so for the next 5 years, we know from 2024 to 2028, one of the things that they're focusing on is the Pregnant Worker Fairness Act. So employers definitely need to take this seriously, and when in doubt, work closely with your HR professional or employment lawyer.
Wow, am I glad you went through that. And I'm still back where you said 40 weeks. I can hear a manager now, 40 weeks. and now we're going to have 12 weeks of FMLA, and then they're going to have a year of the Pump Act. I can hear it
Well,
already.
you can run the FMLA concurrently as long as you designate that.
Right.
That can get run concurrently. But
Okay.
yeah, no,
Wow.
40 weeks is a long time.
Yeah.
Especially if you think about it, this could apply even before the birth. So if
Right.
someone's trying to get pregnant, it can cover, 20, 30 weeks before the person's even pregnant.
Hmm. Wow. Okay, well, you just made every business owner shake their head.
That's
Um,
what I do.
and you're getting even better at it every time we chat. So, thanks so much, David, for bringing us up to date on the Pregnant Workers Fairness Act.
Thank you.